One of our legal analysts, Ronald Krotoszynski, is a law professor from the University of Alabama, an expert on constitutional law. Professor, tell us your reaction when you read this unanimous decision.
Sure. It's a very well-written, scholarly, thorough opinion. Also, I would note that it was issued per curiam, meaning by the court. So the opinion is not signed or authored by a single member of the three-judge panel. They chose to speak with one voice. We don't know who wrote the opinion or what parts of the opinion were written by each of these judges, but they all joined it without any limitation or qualification. I think that was meant to send a message. They're literally speaking with one voice.
And a lot of us were listening to the hearing when it was broadcast live and trying to figure out, in the vigorous questioning by these three justices of both sides of the federal government and Washington state, if we could detect what direction this was going. At the end of the day, these three judges couldn't have been clearer in siding with the state of Washington and the state of Minnesota, and pretty well rejecting almost everything that the federal government had asserted here.
That's exactly right, Ian. And in fact, there was a contradiction of sorts in the arguments that the Department of Justice put forward. On the one hand, they said, look at court judges, you can't review this. The president has unfettered, unlimited discretion. It's unreviewable. But at the same time, they made arguments premised on unsubstantiated threats of possible threats to safety and national security. Without offering evidence in the district court. They, I suppose, wanted the panel to take judicial notice of these arguments. So there was really a kind of intrinsic contradiction in the arguments that the Department of Justice put forward, and ultimately their arguments were squarely rejected. They kind of collapsed under their own lack of weight.
I want to hear from the Attorney General of Washington State. He spoke exactly on that issue, this assertion by the Department of Justice that these kinds of executive orders are not reviewable by a court. Let's listen.
The question was asked, is it the view of the Justice Department that those actions are unreviewable? And after a rather lengthy pause, the answer was yes. Here's what the Ninth Circuit had to say about that. There is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy.
I know there are lots of options about what could happen next, but based on your expertise, what do you think is likely to happen next year?
Well, there are two options for the Trump administration and the Department of Justice. They could seek en banc review within the Ninth Circuit and ask the en banc Ninth Circuit to grant a stay of the stay or reverse the temporary restraining order. I think that's unlikely. They're not likely to do any better with more Ninth Circuit judges than with the three they've already had arguments before. They could also go to the Supreme Court of the United States, which currently has 8 rather than 9 members. Given the strength of this opinion, it's not a particularly ideological opinion. It's a very technical opinion. It handles the standing and reviewability arguments very clearly. And the key legal argument that they find merit about procedural due process is so clearly established in U.S. law under our Fifth Amendment's due process clause. And they make just a compelling case that procedural due process requires more process than is provided for in this executive order. I almost think the opinion is written directly as a kind of brief of sorts to Anthony Kennedy, who's one of the swing members of the court. But even if Justice Kennedy voted to grant the relief the Department of Justice seeks, it would be a 4-4 tie. I think there are probably at least four votes to sustain the views of the per curiam Ninth Circuit panel, and possibly, I'll go out on a limb here and say 6. I could easily imagine Chief Justice Roberts and Associate Justice Kennedy finding the reasoning of the Ninth Circuit persuasive. And again, it was a panel comprised of 2 democratically appointed judges and 1 Republican judge. The Republican judge didn't concur, didn't dissent, joined that opinion in full. It's as much Judge Clifton's decision as it is the decision of the other 2 members of the panel. So they can go to the Supreme Court, but I think their prospects for success are meager.
We have just half a minute, but I do want to ask you this. There is another option here. That option would be a different executive order that is much less broad than the one that the president originally wrote. That's theoretical, but no sign that he would take that course.
Well, that would be the most prudent course of action. In fact, the Trump administration has already conceded a flaw in the original executive order insofar as it is arguably applicable to people who hold green cards. There's no meritorious legal argument that a green card holder doesn't have a right to come and go from the United States as she pleases. So the White House counsel put out a memorandum clarifying the executive order, but as the Ninth Circuit properly notes, the White House counsel can't issue executive orders in the name of the president and can't amend them, and the White House counsel's orders aren't binding on people at CPB. So, yes, that would be the logical, rational, prudent thing to do. I think that's exactly right.
But let's not hold our breath that the executive order will be rewritten. Professor Krotoszynski, thank you very much for speaking with us this evening.
Thank you. I enjoyed it.